Hi. In this video, we're going to review some of the rules that we've learned concerning the buyer's remedies under Article 2 of the Uniform Commercial Code. We're going to talk about two subjects. First are the buyer's remedies when the seller repudiates, when the seller fails to deliver, when the seller becomes insolvent after receiving payment from the buyer, and when the seller gives the buyer reasonable grounds for feeling insecure about the seller's ability to perform. Second, we're going to talk about the buyer's remedies when the seller delivers the goods, but the delivery does not conform to the contract. There's a related topic, which is the buyer's remedies when the seller breaches a warranty. We'll be talking about that topic in another video. If you look at the table on the screen, you'll see that on the left-hand column there are a list of remedies that the buyer might have. The buyer might withhold or suspend payment, might cancel, might await delivery, and so forth. Then there are three columns to the right of that. The first column lists the remedies that are available when the buyer repudiates or fails to deliver. The second lists the remedies that are available when the seller becomes insolvent. And the third column lists the remedies when the seller gives the buyer reasonable grounds for feeling insecure. Let's start by talking about the buyer's remedies when the seller repudiates or fails to deliver. Well, Section 2610B says that when there's a repudiation, the buyer may resort to any of the remedies that are available in Section 2711 for when the seller fails to deliver. Section 2711 does not say expressly that the buyer may withhold or suspend payment, but it does say that the buyer may recover any payments that have already been made, and so it's implicit that the buyer doesn't have to make any further payments. In addition, if the seller has repudiated or failed to deliver, the buyer could cancel. Third, if the seller repudiates, the buyer might simply wait until to see if the seller will retract the repudiation, as the seller has a right to do under Section 2611(1). Section 2610A says the buyer does not have to act immediately. Now, if the buyer has already paid for the goods, Section 2711(1) again says that the buyer may recover any payments that have been made. Now, what if the seller fails to deliver, but the buyer is also in breach? Well, Section 2718(2) and 3 say that the buyer may recover in restitution any payments that the buyer has made to the seller, even if the buyer is in breach. However, from those payments, two things must be subtracted. First, either the sum of $500 or 20% of the contract, whichever is less, and second, any damages that the seller has suffered because of the buyer's breach. In addition, the buyer may recover damages if the seller has repudiated or failed to deliver. There are two basic ways for measuring the damages that the buyer may recover. One is the difference between the cover price and the contract price. The cover price is the price at which the buyer makes a purchase of a substitute good. We'll be talking a little bit more about that later. In addition, the buyer could collect the difference between the market price of the good and the contract price. Now, there are three ways that the buyer may force the seller to deliver the goods. The first is through specific performance. If the buyer can show that the goods were unique or that there are other proper circumstances, as we saw in the Leclerc gas case, then the buyer can force the seller to deliver the goods. But this remedy is subject to all the equitable limitations that are always applicable to specific performance. Second, the buyer may recover the goods through a replevin action. To recover in replevin, the buyer has to show that the buyer paid for the goods, that the goods have been identified, and then it would be difficult for the buyer to cover. Another possibility is insolvency recovery. This recovery is available when the buyer is insolvent. Not in all instances, but when the seller is insolvent. If the buyer can show that the seller became insolvent within 10 days of having received a payment from the buyer can, upon making a payment for the rest of the goods, recover the goods that are in the seller's possession. Again, those goods have to be identified. The code says the buyer has to have a special property interest in them, which means that they have to have been identified. What else can the buyer do if the seller is insolvent? Well, the seller's insolvency may give the buyer a feeling of insecurity as to the seller's ability to perform, and so we could look at the last column The buyer's remedy upon feeling insecure under Section 26091 is simply to demand adequate assurance of performance from the seller, and if the seller refuses or fails to provide that adequate assurance, or until the seller does that, the buyer may suspend performance. If the seller never provides it, well, then that's repudiation. All right, those are the different remedies that are available to a buyer. Now, how do these remedies provisions turn up in the actual cases? Well, it's important to understand that even though that these are remedy provisions for the buyer, many of them are self-help provisions, and as a result, they may give the buyer various defenses. Let's first talk about 3 defenses that the buyer may have based on these remedies. Suppose the seller sues the buyer and says, well, the buyer promised to accept and pay for goods, but didn't do it. Well, the buyer's first defense might be, well, I had a right to suspend payment. That's why I didn't pay you. I had a right to suspend payment because the seller gave me reasonable grounds for feeling insecure, and I demanded that the seller provide me with adequate assurance of performance. Another defense might be, well, yeah, sure, I didn't pay for the goods. I didn't pay for them because I had a right to cancel the whole contract because the seller repudiated the whole contract or breached the whole by failing to deliver when payment was due. And a third defense would be related, which was that I, the buyer, had a right to cancel with respect to one installment because the seller repudiated the obligation to deliver the installment or failed to deliver it when payment was due. Now, the buyer also may be able to use these remedies to assert an affirmative claim for the price paid plus various damage measurements, including the market damages or the cover damages. Let's talk first about market damages. The buyer's claim would be, well, S promised to transfer and deliver the goods to me and failed to do it. The buyer would then say, as a remedy, S should have to pay damages equal to the price already paid. I want to recover the money that I've already paid, and the difference between the market price and the contract price, plus any incidental damages and consequential damages. The buyer's entitled to consequential damages from the seller, even though the seller is not entitled to consequential damages when the buyer breaches, but less any expenses saved. Now, what could the seller reply? Well, we saw one possible reply, which is that the buyer is not entitled to market price damages if the buyer covered. That's in section 2-713, comment number 5. An alternative would be for the buyer to seek cover damages. Here the buyer would claim that the seller promised to transfer and deliver the goods and didn't do it. Then the buyer would say that as a remedy, the seller should have to pay damages equal to the price already paid and the difference between the cover price and the contract price, plus incidental and consequential damages, but less expenses saved. Now, what would the seller's reply to that be? Well, the seller might say that the buyer is not entitled to the cover price difference because the buyer didn't cover. In other words, the buyer did not make, in good faith and without unreasonable delay, a reasonable purchase in substitution for the goods due from the seller. And we talked about various examples of why something might not be done in good faith. Maybe there's some collusion about the price, or there was an unreasonable delay and the price changed, or if not a reasonable purchase, the goods aren't comparable, or they're too expensive, or they weren't purchased in substitution, meaning the buyer would have purchased those goods anyway. Now, what about the buyer's ability to force delivery? Well, here the buyer might say, well, the seller promised to transfer the goods and didn't do it, and the buyer's first request might be, well, I'm entitled to replevin because the goods have been identified and I'm unable to cover. Or the buyer might say, I'm entitled to recover the goods identified because the seller became insolvent within 10 days after receipt of the first installment for the price. And of course, the buyer would have to tender the remaining price in order to get the goods. Thirdly, the buyer might say, well, the court should award specific performance to me because the goods are unique or there are other proper circumstances. And we saw an example of that in the Laclede Gas v. Amoco Oil case, where the goods were not really unique. Propane gas is not unique. It's just that the buyer could not find a long-term contract with anybody else, and the buyer really needed a long-term contract because of its obligations to people to whom it was going to resell the gas. Now, the seller has a reply to that third request for damages, which the seller might say, well, the court has discretion to deny specific performance for equitable reasons. In the Leclerc gas case, we saw an example of that. Amico said, well, no, you shouldn't award specific performance because, among other reasons, it would be difficult to monitor the award of specific performance over a long time. Of course, that argument was not the greatest argument, since Amico was essentially saying, don't give specific performance because we might misbehave. The court didn't think too much about that. All right. Finally, the buyer may be able to request restitution. And here the buyer's claim is a lot like the claim that we saw that in Britton v. Turner. The buyer would claim that although I breached the contract, either by repudiating or by failing to pay the price when payment was due, I'm entitled to restitution of the payments made to the seller minus $500 or 20%, whichever is less. That's what Section 2718.2 says, and we saw an example of that kind of claim in the R.E. Davis chemical case v. Diasonics. Now, the seller, however, may assert a counterclaim, which is that the buyer failed to pay and accept the goods and is liable for any damages. Section 2718.3 says that the buyer has to have subtracted out of the restitution amount any damages caused to the seller, and those damages would be measured just in the ways that Section 2703 permits damages to be calculated. Now, let's talk about the second subject, which is the buyer's ability to recover if the seller delivers but the goods are not conforming. Well, here we saw several different principles, starting with Section 2601's rule, which the buyer has various options when the seller delivers non-conforming goods. In particular, the buyer can accept the goods, or the buyer can reject the goods, or the buyer can accept some of the goods and reject the other goods. Now, what are the buyer's rights and duties if the buyer accepts non-conforming goods? Well, Section 2607.1 says that the buyer has a duty to pay for any goods which are accepted. If the buyer accepts the goods, even though they're defective, the buyer has to pay for them. However, Section 2714.1 says that the buyer is entitled to recover damages for the non-conformity. How are the damages to be measured? Well, Section 2714.1 says that they can be measured in any reasonable manner. So, for example, if I order long-sleeve shirts and a company sends me short-sleeve shirts, I might be able to accept them. I'd have to pay the price, but I would be entitled to the difference in value, say, between long-sleeve shirts and short-sleeve shirts. That might be one reasonable way of measuring the damages. The buyer's other alternative, again, is to reject the non-conforming goods. Now, if the buyer rejects the non-conforming goods, the buyer is entitled to recover the purchase price for those goods and collect any damages. That's what 2711.1 says. But what about the goods themselves if they've already been delivered? Well, if the buyer has not paid for the goods, the buyer has a duty to hold the goods for a reasonable time so that the seller can pick them up or have them shipped someplace else. If the buyer already has paid for the goods, then the buyer has a security interest in those goods, a security interest which secures the purchase price that the buyer has paid for them. And the buyer would have a right to sell the goods just like anybody would have a right to sell the goods that they had a security interest in. The buyer could then apply the proceeds from the sale to offset the purchase price that the seller owes the buyer. The return of the purchase price, I should say. How do these different provisions apply in the cases? Well, the buyer's claim might be, well, the seller delivered non-conforming goods. Then the buyer has two possible remedy requests. First, the buyer might say, well, having accepted and paid for the goods, I'm entitled to damages measured in any reasonable manner. That's if the buyer has accepted the goods. What if the buyer has rejected the goods? Well, the buyer might say, well, having rejected the goods, I'm entitled to recover the price of the goods plus any damages. We sort of saw an example of that in the Fertico v. Phosphate chemical case. That's the way the dissent characterized what the buyer had done. The dissent said, well, what the buyer had done is rejected the goods, so the buyer should be able to recover the purchase price paid for the goods, plus any damages that were suffered, but nothing more than that. All right, those are some of the rules that we've learned concerning remedies under Article 2 of the Uniform Commercial Code. Thank you very much for listening.